All right, folks, thank you. Our final panel of the day. We've heard about the technology and the advocacy and the policy, and what does this now mean for what the law should look like? So we're delighted to have some of the folks who are involved in debating and shaping the law, and we're very pleased to have one of our Future Privacy Forum Advisory Board members and one of the smarter chief privacy officers in the land who I look to for insight quite often. So very appreciative of having our board member, David Hoffman, the privacy and security lead at Intel Corporation.
Great, thanks a lot, Jules. And I want to jump right into this very quickly, so I'm not going to take a lot of time. I do want to thank Jules very much, and I'm deeply honored to be here with this panel, and I'm not going to waste a lot of time speaking because their remarks, I've read their papers and their work, they're truly incredible, and I want to jump right into that. I will introduce real quickly, although the deeper and more thorough introductions are in the materials that you had. First, we are going to have Professor Dan Sullivan from George Washington Law School is going to be speaking on a paper that he recently wrote with Paul Schwartz. Then Professor Jane Yakowitz from Brooklyn Law School is going to be speaking on a paper that she recently wrote. Then Harley Geiger from CDT is going to break in and talk about how we apply some of these principles in a healthcare situation into healthcare data. And then Rob van Eyck from the Dutch Data Protection Authority is going to talk about how we apply some of these principles, particularly in the EU context. Professor Sullivan.
Okay, so this is work that I've done with Professor Paul Schwartz at Berkeley Law School. We wrote a paper to try to tackle what we call the PII problem, or this big difficulty of how do we define PII. There are so many privacy laws that rely and center upon PII as a center trigger point for the applicability of certain laws, everything from data breach notification laws to the COPPA to the Gramm-Leach-Bliley Act, the High-Tech Act, and so on and so forth. All rely on the concept of PII. But one of the main problems with PII is that the current approaches that the laws take to defining PII are all deeply flawed. And we looked at the various approaches, and there are basically three approaches that the law will take in terms, if we categorize them. One we call the tautological approach, which is the law will say that personally identifiable information is all information that's identifiable to the person. So it doesn't really answer any questions, and it begs the question, and it's pretty useless as a standard. Then there are approaches. Another approach is the non-public information approach, which is to say that any information that's non-public is PII, but being public or not public really does not map on to whether or not something's PII or not PII. So that approach is deeply flawed. And then the third approach is to what we call the specific types approach, which is to identify specific things in the law that constitute PII. So the law will say, okay, these are the things that are PII, and everything else isn't. And that approach is obviously deeply flawed as well. The laws rarely ever get it right, and things change over time. What's identifiable at one point in time, what's not identifiable at one point in time might be identifiable later on. So that's also a problematic approach as well. So the law really has three very bad answers to what's PII. There has been scholarship that has suggested, well, maybe PII is just not a workable concept. And a number of studies and research has shown that one of the challenges that PII faces is, well, it's really hard to de-identify data, and data can be readily re-identified. We spoke about that earlier, and that this difficulty with actually determining, well, is how identifiable data is. One option in light of those studies is to say, well, maybe we should abandon PII as a concept. Ultimately, Paul Schwartz and I conclude that we really can't and shouldn't abandon PII as a concept. It's so central for the law. And it really does constitute, it's not the only privacy harm, but it constitutes a very large constellation of privacy harms if data is identified about a person versus if data is not identified by a person. And so we think that keeping the distinction plays such an important function that it shouldn't just be jettisoned. We shouldn't just give up on it, and giving up on it, I think, would create more chaos. But that said, one of the challenges with PII is that it's a little bit of a moving target. It's hard to fix and make a definitive answer in this once and for all. And I think that's one of the reasons why we've had such a difficult time when it comes to PII, is because we don't have fixed answers. What's identifiable depends, for example, what could be identified to a person depends on one technology, which is changing and evolving. So new technologies and new abilities and techniques to identify data can emerge in the future. So at time one, something might not be identifiable, but that could become PII down the road. In addition, what makes something identifiable is the other data out there. It's kind of like data is kind of like the pollution that's increasingly growing around the world with satellites, dead space debris that over time keeps accumulating and accumulating, and now there's a greater risk of hitting something. And the same thing with data. As people put more personal information up online in various websites and social media sites and comments and posting movie reviews on IMDb, which is what actually enabled the Netflix researchers to identify people. So the more you put data out there about yourself and the more people that put data out there about themselves, the more likely it is that any one piece of data could then be, or a data set could be identifiable depending on other data. And so that can also change over time. So we're dealing with a moving target. And ultimately, what Paul and I conclude is that we need to think of identification not in absolutes, but in terms of risk. And it's not an all or nothing kind of thing. It's a continuum of risk. And ultimately, we build our solution as a standards-based solution, understanding that identification is about risk and it's not about absolutes. There's rarely going to be a case where we know for absolute perfect certainty that this data could never be identified at any point ever in the history of humankind. That's just not really a feasible way to think about this. There is a risk, but there's low risks and moderate risks and high risks. And so we basically built a continuum of what should the legal protections be based on our ability to determine this risk to the best of our ability at this particular time. What protection should data get? And so we basically, everything is a simplification of reality. And so we're trying to carve some lines in this continuum. On the one hand, you have identified information that has already been identified. That category we think should get the full set of fair information practices. That gets the full set of privacy protections. When it comes to data that's no risk of, or not no risk, but very low risk of being identified, we think that should not have those protections. If there are other problems that are created by it, those problems should be addressed. So we don't think it should be totally unregulated under all circumstances, but at least for the purpose of this and identification, we think that basically that data is safe for the time being. Then there's a pretty large category in the middle, though, of what we call identifiable information. This is not identified individuals. It's information that could be identifiable to a person. And there's some of that information in a wide spectrum of risk of identifiability. Some has a low risk, some has a moderate, some has a high risk. When there's a very high risk or a high likelihood that information that's identifiable could be identified, we think that should be treated the same as identified with a full range of FIPS. That ultimately you can't circumvent the protections of having identified information by saying, oh, we'll just strip off the name and then we'll just pop it on later on. So we want to prevent end runs around or very, very high risky uses of information that are identifiable, but they're just one step away from being identified. And if that's the case, we think that they're basically should be the functional equivalent of identified. But what about this category of identifiable information that's not a high risk, but there's a risk? For that, we think we should have some fair information practices, but not all. And ultimately, we conclude that certain fair information practices make more sense when we're dealing with identifiable data. So notice to the individual, giving the individual access rights to that information, we think doesn't make sense when it's identifiable, because then it almost forces you to make it identifiable so the individual could have access, you'd verify identity, and so on. And so we actually think that could almost be kind of productive to require certain fair information practices when it comes to identifiable information. But other things we think should be there, even regardless of the fact that it's just identifiable and not identified. Data security, data quality, and basic transparency over the uses of that information, not necessarily individual notice, but basic transparency over what types of data you have and how you're using it and how you are, in fact, storing it and maintaining its de-identified status should be transparent. And so we think that those fair information practices, the subset of fair information practices, make sense in that context. And so we kind of have more fair information practices as the risk of identification gets high or is identified, a moderate set of fair information practices for the middle category, and then little to no fair information practices at the very bottom end of that spectrum. And we think that that is a more nuanced approach, but a workable approach to this issue, which is really about risk and really does call for nuance. And also we recognize this is a moving target. And so, what we determine today might change in the future as we learn more, as new data emerges, and so on. And so it's a flexible and not a kind of fixed standard, but a flexible standard that will change over time. And that's ultimately what we propose. We call this PII 2.0.
Thank you very much, Professor Solov. I think that was very helpful, especially laying out the concepts of different levels or categories of the FIPS that would apply to different areas of risk. I now want to transition to Professor Yakowitz, particularly Professor Yakowitz, because I was struck when reading your article about the social benefits instead of the risks, and how we might want to drive different requirements based on looking at the benefits of the use of the data, which I think could match up very well with Dr. Solov's model that he just described.
Yeah, thanks. So my motivation for writing Tragedy of the Data Commons was to correct what I see as a privacy focus problem. So dissatisfaction with American privacy law is mounting, and even I, information lover that I am, agree that the law ought to be making some changes right now.
Move closer.
Oh, okay. I'm being told you can. All right, here we go. An unfortunate trend in the privacy advocacy recently has been to focus on anonymized research data, which is why we're all here, of course. And I think I say this is unfortunate. By the way, the fear is reflected even in the FTC's recent privacy by design framework, which more or less adopts Paul Ohm's policy prescription and encourages its constituents to abandon the distinction between anonymized data and identified data and treat it all with great caution. So I argue that research data is an exceptionally poor choice of target during this critical period and window of privacy reform. So the data that fuels most of the quantitative health and social science research in this country is made possible by publicly available data that has undergone some sort of anonymization process. I call this the data commons. We're all in it, and it includes very detailed information about us. It includes our tax returns and our hospital records and so on. And in theory, the commons gives us the best of both worlds because it allows researchers to test hypotheses and produce generalizable results without exposing anybody's personal information. But at the same time, I completely acknowledge that we are all shouldering some risk that a bad actor might use auxiliary information to re-identify us. I've never suggested that re-identification risk is zero. That would be a ridiculous position. Other panelists have talked at length today about this re-identification risk. At this point, it's not new to anybody here, but the looming policy question then is whether current data policy in the US strikes the right balance between the risks of being re-identified on one hand and the utility of sharing data more or less publicly on the other. Paul Ohm and other scholars say the risk is too high and we need tougher standards. I'm not quite sure where Dan Sullivan fits. I think Paul and I both probably think that you're on our side, which is kind of interesting. But yeah, but I argue that the utility of this public data is so great and the realistic risks so small that the law actually should be doing more to promote the sharing of research data. So I propose a legal safe harbor for data producers when they use some pretty basic anonymization techniques that will be implementable by non-experts and will guard against most attacks just fine. So let me briefly sketch out why I think the cost-benefit calculus comes out the way I suggest it does, and then I'll end with a description of my policy proposals. Okay, so first, we've talked a lot today about the utility of data. Normally when I give my talk with a slide deck, I have a picture of a panda behind me so that you all sort of become emotionally attached to the good uses of data. So just imagine a panda. Okay. So we've heard about health and innovation, how health and innovation can be improved through public data. But public research data has also been used to support and dispel various theories about welfare benefits, drug policy, the housing crisis, and education, which is the sort of sector that I came from. It's been used to expose housing and employment discrimination and to foil pernicious stereotypes, too. So the data commons is vital to information justice. It reveals what can't be discerned through any one person's experience. For this reason, I think consent models would be a particularly unwise route to go down. We have a civic duty to put our data in the commons. This is how we pay sort of our information taxes, and this provides a fairer distribution of knowledge through indirect benefits from the research community. But it's also important that the data be public, or at least semi-public, by which I mean any credible researcher can access it if they want to. Because replication by peers and by rivals is an absolute requirement for quality assurance in the health and social sciences. And also, disingenuous privacy arguments are all too often deployed to serve self-interest of whatever agency happens to hold the data. So I review even restricted access policies if they come with quite a bit of discretion with a healthy amount of skepticism. So public data is good, but against this utility, we do have to weigh the risks. You've heard a lot about de-anonymization studies, and I think the trouble is that the media and the legal community has somewhat uncritically accepted lessons from the de-anonymization studies, especially the Netflix study and the famous study of Dr. Sweeney's re-identifying Governor Weld, such that it's now widely believed that these sorts of attacks are replicable and scalable and maybe are happening right now as we speak. And because of that, there have been pushes to treat every single piece of information in a database as if it might be an indirect identifier or a quasi-identifier in HIPAA speak. So in fact, the attack algorithms explored in the de-anonymization literature so far require very specific conditions to be met in order for the attacks to work without being riddled with false match error. They require the attacker to be confident that somebody who looks unique both in the data set, the anonymized data set, and the general population actually are unique. So these conditions actually are quite rarely met. In fact, they were not even met in the proof of concept studies of Netflix or Governor Weld. There was some chance that the uniques were not, what were perceived to be unique individuals were not actually unique. Using the Netflix example, Netflix doesn't have information about every movie that every person has watched. So somebody who looks unique, even in the data set that they released to the public, might not be unique among those people in the data set. Right, and the algorithm does not correct for that error. So, and other studies have found that it's actually quite hard to connect two contemporary sources of data with each other without having error. And this isn't due to sort of lack of processing speed or technical capability. This actually is reflecting something about the inherently messy nature of people and of data. It's hard to do these things. It's hard to do them accurately. And so even if you have a 90% match rate, which would be remarkable, once you do that, I'm less concerned about the accretion problems than some others, because once you do that 3 or 4 times, then the chance that somebody's line of data has an error is going to start peaking over 50%. So also these attacks require the adversaries to understand the attack algorithm and the data that they're working with in a theoretical level. So these are not the sorts of things that, at least the Netflix attack algorithm, for example, could not be easily replicated by the average hacker in Eastern Europe, say. So, okay, so while the theoretical risks of re-identification are small, I think the realistic risks are even smaller. What's remarkable about this turn of focus to research data is that they're responding basically to potential alone. I didn't know of any incidents of re-identification of a public data set for a purpose other than re-identification risk research until recently. But now I have one example where it's not a journalist proving that this can be done, and it's not a researcher proving that it can be done. The New York Times just published an article about journalists who were re-identifying doctors in the National Practitioners Data Bank. They have a medical disciplining data set, public data set, and they could use exact settlement amounts, which were both in court records and in the de-identified data in order to re-identify the doctors. Obviously not a very well anonymized data set, but in any case, I know an example. Still, I don't know of any re-identification attack that has been done yet on a halfway decently anonymized data set. And it's not surprising. Re-identification attacks are difficult, they're costly, and there's a lot of lower hanging fruit for malfeasors to exploit. We've talked about some of this today. So all right, so this brings me to my proposal. Since the social utility of research data is so great, with this type of data, I don't think we need more privacy protection, and I don't think we need more nuance either. That's perhaps where Professor Sullivan and I differ quite a bit. I actually think we'd be better off with less of both. So I propose a policy that provides a safe harbor for data producers, as long as they use some basic anonymization procedures. It has three aspects, the proposal that is. So first of all, it clarifies what a data producer is expected to do in order to anonymize a data set. Then it immunizes the data producer from privacy-related liability if they've done the first step correctly. And then finally, it punishes harshly any recipient of anonymized data who re-identifies a subject in the data set. So let me very quickly roll out each part, especially the first one, since that's probably the most interesting to you. So data producer would be expected, of course, to strip direct identifiers, names, faces, social security numbers, addresses, etc. But then they'd have to do something else to make sure that it can't be easily linked again to auxiliary information. So to do this, I propose that they should have to do one of two things. Either report data only on a random sample that's small enough so that they know that it would be difficult to re-identify, or they have to check for minimum subgroup counts, in other words, k-anonymity. And the subgroups would be determined by the intersection of the variables that are routinely collected and published in identified form on all or nearly all of some target population. So geographic information, race, sex, etc. But in context, there will be other types of indirect identifiers too. So to be clear, the standard is much less onerous and more risky than current requirements under HIPAA and FERPA. So I suspect that a lot of the disclosure risk researchers in the audience right now are probably shifting in their seat and feeling uncomfortable. But it's this move away from the highly nuanced standard is intentional. We need protocols that are good enough, but can also be implemented by less sophisticated data holders, because increasingly they have very, very valuable data. The optimal theoretical risk here is not zero, and we shouldn't be striving for zero. We should be striving for something low enough where it's not going to be worth the time of a malfeasor to bother doing these attacks. So, and sophisticated users, data producers like the U.S. Census, of course, ought to continue to use their higher standards, their data swapping techniques and their random noise adding, but this sets a minimum requirement. So then if a data producer does this, then they would be immune from liability based on privacy torts and the federal statutory penalties under HIPAA and FERPA, et cetera, and also contractual liability based on confidentiality agreements. And then finally, the scheme penalizes anybody who does take this database and re-identifies somebody. And the liability accrues the instant that the adversary discloses the identity of the person and some piece of non-public information to someone other than the data producer. So I design it this way so that disclosure risk can continue to happen, because that, of course, is very important. So this scheme fills an obvious hole that's in current privacy law. Right now we regulate data releasers only, and the law stays neutral as to use, even data abuses like re-identification. So this at least corrects for that error. I look forward to your questions.
Thank you very much. And I definitely want to come back. Harley, can you relate these discussions then to where we currently are with some of the most sensitive data that at least most of the regulatory constructs have held, with being health data?
So, can you hear me? So a lot of what's been said in the panel already, it applies very well to health data. The risk of anonymization, the risk of re-identification is quite low, although the consequences of re-identification are very, very severe. We don't think that that anonymization is ever going to get to zero. However, we think that there are some ways that we can improve the standard. The HIPAA de-identification standard is pretty strong. Commercial data providers are not right now re-identifying at a high rate, at least as near as we can tell. It's expensive and it's a huge risk for any of them to attempt it. Nonetheless, the risk is there. Latanya Sweeney's work clearly points that out, and it's compounded by the fact that we do not regulate de-identified data. And as everyone is aware, the growing availability of large data sets online are going to make this risk more high in the future. And as we transition to electronic health records, there are going to be several fields in those health records that are going to raise the risk of re-identification as well, such as physicians' free text notes. So we think that it's worth revisiting the HIPAA de-identification standard, if anything, to take it off the table for most uses. CDT issued a paper in 2009 on reforming the HIPAA de-identification standard, and we held a workshop several weeks ago, and many of you were there. And so from our perspective, this is still an ongoing conversation, and there are still a lot of policy approaches that are open to us and that we're just still considering. And so here are some of them. First, it was just proposed that we would have a straight prohibition on re-identification. And you would think that might enjoy a lot of universal support, but there are actually quite a few problems with it. First, a legal prohibition on re-identification would make the work of people like Dr. Sweeney or other security researchers very difficult, and it might constrain them from actually cracking the HIPAA de-identification standard and saying this standard is actually inefficient, or cracking a certain data set and saying this data set is not adequately protected. We think that there's value in that work. A prohibition would also constrain the marketplace due to liability issues. You would not want to give your de-identified data set to somebody that, or at least you'd be more hesitant about giving a de-identified data set to somebody that has a greater chance of re-identifying it. So a prohibition with some exceptions is an option, but the exceptions would be difficult to craft and uphold. Another possibility is to require a data use agreement between two entities that are sharing de-identified data sets, and there is a lot of evidence that this is already occurring. In improving the current standard, we are concerned about the long-term viability of the current HIPAA de-identification standard, particularly due, as I said, to uncovered fields in electronic health records, like genetic information, diagnostic codes, and we do not think that the current safe harbor standard should be eliminated. That would actually cause a lot of market disruption for people that are already using the de-identification standard. But we think that HHS ought to at least work with NIST to both strengthen the current standard and to identify other methodologies that can achieve an acceptable low risk of re-identification. And then HHS and NIST should work together to release guidelines on how to use those methodologies. And then HHS and NIST should revisit those standards every few years, every X years. The last policy issue that we're struggling with a little bit is the most challenging, that is transparency. And for our uses of de-identified data, a big challenge in dealing with de-identified data is the uses for which people will have moral, religious, policy objections to. But providing those individuals with an opt-out, if that's even possible, will introduce a lot of bias into research. Yet at the same time, according to surveys and focus groups, the majority of the public actually supports responsible use of de-identified data for research purposes. But educating the public about those uses, those beneficial uses, and who should do the educating is a challenge in part due to the technical nature of the subject. So these are the major policy issues that CDT is considering, and we hope to release our paper in early 2012. Thank you for having me.
Harley, thank you very much. Rob, I wanted to ask you to then comment on this from the European Union perspective. There's been a lot of work that has happened in Europe on both, I think, the two related issues that we're seeing come out in this discussion. Number one, what are the different attributes and pieces of data that need to be combined together to fall under a definition of personal data in the European context, or PII here in the US context? And then the sort of flip side of how much do you have to break attributes apart to be able to de-identify data, to take it out of that category when it's already there? Maybe you could give us a little bit of the European perspective from the analysis that's come out overseas.
Yeah, thank you for the opportunity. Like Peter in the previous panel, I have to say I'm talking to for myself this panel. Let's take the paper which you just talked about, Ms. Solvey, of PII 2.0. I think it's maybe very interesting to see that this framework you were describing with the three vertical areas much resembles the framework which we have in Europe. To explain that, I first want to make sure that we all talk on the same page. The definition of personal data in Europe is as follows. Personal data shall mean any information relating to an identified or identifiable natural person. And an identifiable person is one who can be identified directly or indirectly, in particular by reference to an identification number or to one or more factors specific to his physical, psychological, mental, economic, cultural, or social identity. Of course, this is an open norm which needs to be transposed in national legislation. And at least for the Netherlands, I can say that in our memorandum of comments, which accompanies the law, we would have at least 5 categories. The first one would be direct identifiability. The next one would be indirect identifiability, which would fall into 2 categories. Category A would be there's a high degree of identifiability, and this would slide down to low level of identifiability. And then the 5th category would be that we will be looking at non-identifiable data in the end. And the hard part in all this is, where do you draw the line? Because if you go in this, I'll use a vertical model instead of a horizontal one. If you go in below in the model, you come up to a certain point where the identifiability is low enough, and which you can conclude, okay, we're not dealing with personal data anymore. And in that case, the law would not apply anymore. So that brings me to your second question. To which degree would entities have to go in order to anonymize and not be covered by the law? And in my opinion, rephrasing that question would be something like, when does it become a disproportionate effort to re-identify or make an identifiability possible? And the thing is, in the directive, there are a number of places where this is explained a little bit more, and this also falls into the subject we're talking about, that's the statistical exemption of data. And one of these examples is, and this is from Article 6, further processing of data for historical, statistical, or scientific purposes shall not be considered as incompatible provided that member states provide appropriate safeguards. Since we're talking about privacy risks all the time, one of the risks that has been put forward is the risk of re-identification. And the way we use this within the European framework and also within the Dutch law is that re-identification itself is a further processing or a secondary use, if you wish, for which you would need to acquire a legitimate ground. And there are a number of ways to acquire this legitimate ground. One of them is to get the consent of the data subjects, or if there is a legitimate business interest. Thing is that, like Mr. Rocca said in panel number 2, a risk-based approach the question would be, is re-identification possible, and how low should that be then in the end? And in Europe, at least, there are two ways of dealing with mitigating the risks, and one of them is taking technical measures, and another one is taking organizational measures. And that's one thing I did not hear a lot here in the discussions we had today. An example of an organizational measure would be the use of, for instance, a trusted third party, in which you could use, if you have like an identifier, and then the key you would give away to a third party, and there will be contracts and organizational measurements to make sure that the identification risk is mitigated. Let's see. The third question you asked is, should there be a lower standard for anonymization for research? My personal opinion is that at the moment it's already pretty low in comparison to other types of data processing, and you have to take into account that technology is developing fast, like Mr. D'Acquisti showed us this morning. The ways you can use technology are just limited by imagination, and some of these technologies are maybe disproportionate, like the use of fingerprinting in behavioral advertising, where the intransparency for the user is so high and the use of this technology is so effective that this kind of data gathering and what kind of technology you use to collect your data should be taken into account. That's it for now, and later on I'd like to add something about the proportionality.
Great. I definitely want to come back and talk about proportionality. That would be fantastic. Let me kick off the first question and then take questions from the audience. And I'm going to encourage the panel to interact with each other and speak up when you want to interject. The first, I want to come back as Professor Peter Swire is walking out. I'm sorry, Peter, but I'm just about to quote you. At the beginning of the day, I think Peter mentioned a term calling the erosion of practical obscurity. Did I get that right? Close enough. And I think he's citing three different reasons for this concept of this erosion: the amount of data on the web, the increased efficiency of search, and the fact that then the re-identification risks increase because of that. I think if we take some of what was said on this panel, there's another way we could describe that. Instead of the erosion of practical obscurity, we could describe it as the explosion of the availability of useful research data. And so I want to start with the panel, and I want to ask, starting with Professor Yakowitz, what if we took your concept of the data commons and instead of just looked at it as data sets that are previously existing that identify individuals, but then say, what about supplementing that with all of the information that is increasingly available online, and potentially actively looking to supplement that by, as was suggested in one of the earlier panels, taking data that's offline right now and putting it online, like court records, for example. Would we still feel comfortable about a lower standard for the use of research in that context?
Yeah, so actually, let me make sure I understand the first part of your...
Yeah, it was long.
Well, are you suggesting that we take data that's anonymized and intentionally try to link it, or are you just saying...
Intentionally try to link it to create a greater data commons. Maybe that was what you were originally intending with the data commons.
I wasn't. I was anticipating a way for people who already have data, people or companies who already have data, to share it without risk, you know, shouldering a significant amount of risk. Yeah, I have to say, so I really liked Harlan's discussion of PACER, but I love PACER. So you're not going to get much argument from me about increasing the amount of information we have online. I do acknowledge that as there's more and more information about everybody that could allow pieces of data that at one time we would never categorize as an indirect identifier, if there are enough pieces of them so that they kind of make a fingerprint that we know, you know, with some certainty that it must be only one, there must be only one person who did all this, then I agree we need to watch out for that type of a risk. I don't think we're there yet, and I also think it's very easy to imagine the world falling apart, and it's hard to imagine the world improving, and so I'm a little concerned about, about the law trying to outpace the information on the ground.
I have two quick points or questions for Jane's proposal. One is what constitutes research purposes? What is research? If I'm a company and I say, I don't want to use this for marketing directly, but I just would like to learn information about people. I want to do research about what makes customers tick. Would that be research? Would that not be research? We have to figure out how we define what research is and what's research and what's other research. The other thing, because the commercial use could come way down the road. The other question is, I think that regulating re-identification is tricky with the First Amendment. So I'm not quite sure how you could stop somebody if the data is out there, stop someone from taking that data and analyzing it, and stop them from looking at it and then talking about it and combining it with other data that's out there. So I'm not quite sure how that proposal could work unless there's a very clever way around some of the First Amendment doctrines. So maybe there's a way, there's certain potential ways, but I'm not quite sure how you envision dealing with the First Amendment.
Yeah, I'll respond, but I'll try not to dominate the discussion here. So for what is research, I agree. I'm quite comfortable with research being defined as any generalizable study where you are no longer relating to the individual subjects, but are just trying to understand more about people, even small subcategories of people. So this sounds, I know this sounds troubling. On the other hand, even examples that might seem especially troubling, like, for example, a loan officer being able to discriminate against you because of new types of information, I actually see I see the potential in it. I mean, discrimination is not necessarily bad. If it is, we should treat it. But on the other hand, if we're using new sources of information so that people who at one point looked creditworthy, but it turns out are not actually as creditworthy as we thought they were, are denied a loan, whereas other people who didn't look very creditworthy are actually more likely to pay. I think that's good. I mean, if we just ignored, if we didn't want any business interest conducting research, then loans would be based on income, and that's incredibly regressive. We don't want that. The First Amendment point I'm going to address very briefly because I don't have a great answer yet. I've gotten this response before. I think I see if data is properly anonymized, the amount of work that has to go into re-identifying somebody is not trivial. I don't see it as that different from trying passwords, and like I see a Computer Fraud and Abuse Act sort of similarity to this, but that's a conceptual argument, and I'm not sure that a court would buy it. So,
So, in terms of the prohibition on re-identification, one way to possibly get around some of the First Amendment concerns would not to have an absolute prohibition, but rather to have a safe harbor whereby companies that agree not to re-identify via data use agreement or other means then enjoy certain benefits. So it's not that they're required to sign an agreement to prohibit not to re-identify, but rather they voluntarily decide to sign that agreement not to re-identify.
What about the ones who don't do it, though?
Well,
or the abusers?
So the ones who don't do it should be subject to greater liability or subject to or not be able to enjoy the incentives of the ones that do. It's just one option.
So that you could withhold the incentive, the original incentive of actually being able to use the data for research purposes, for example, since that's something that allegedly would, and in this model I think would be being given. Is that the idea?
Possibly, but that withholding research uses altogether sounds like a somewhat drastic option.
It would force the safe harbor, right?
Yeah.
But even outside the safe harbor, you couldn't really penalize the re-identifier under the First Amendment or make them liable. It's the person maybe potentially generating the data in the first place because they've collected it that could give rise to more greater protections, and it could be the later downstream use once it's out there. And so that becomes, once you get it out there, you have the First Amendment kick in, which makes it a lot harder to make these restrictions unless you have contractual protections, or obviously if someone voluntarily relinquishes First Amendment rights, But the people who might not, the person, I'm just curious and I'm going to do this and I'm going to tell the world, everyone in this particular study, who their names are. That might be very difficult for me to face some liability for that.
But if you signed an agreement saying that, or promising not to
But if I didn't,
re-identify,
if I did, then then the First Amendment will not protect me.
Sure.
Right.
But if I didn't sign an agreement,
well, then obviously the safe harbor doesn't apply.
That's right,
It's
and
a
then I'm
flaw
on-
in the
yeah.
solution.
Yeah, so let me then ask, I found out while I was living in Europe, living in Germany for a couple of years, that many of the countries in Europe's constitutions have not been amended, and those that have, their First Amendment doesn't necessarily equate to free speech rights. So, Rob, I want to ask you, in a model that's not based on providing necessarily the robust ability to be able to speak in that way, but instead focuses on balancing tests around proportionality and the benefits of the use of the data versus the risks from misuse of that data. How does a model like that apply here?
Well, the model works in asking yourself a few questions. It's actually, there's normal tests, and one of the tests is the proportionality test. And that means you need to question a fair balance that has to be struck between the demands of the general interest and the interest of the individual. So, and the second thing is the subsidiarity test, and that boils down to the basic question, can it be done in a different way, which would be less privacy invasive for the user? And in a way, in Article 7F of the directive, this is part of the core balance you make. For the owner of a data set or the one who is processing the data has to pass these first two tests and then has to take into account the privacy harm for the individual. And if that all, if you pass all these tests, then that Article 7F might be your legitimate ground for processing the data.
So a different way of getting a bit what Harley was mentioning earlier about you could have, HHS and NIST here in the United States working together to come up with examples about how you could do this in a more privacy protective way. Here, an explicit obligation that you have an obligation of proportionality to be looking to do that no matter what. So let me open this up now. Do we have questions from the audience that people would like to ask?
Thank you. Alan Goldberg. I'm a lawyer and adjunct professor of health law. I have a question for Harley, please. I'm puzzled by your comment regarding the inability to enact legislation or promulgate regulations regarding prohibiting trying to crack de-identified information in healthcare. By way of example, if you try to crack a safe that is in a bank, attempt to do it, but you're unsuccessful, you don't have a good defense that I'm just trying to prove that the safe is secure. And the same thing for trying to enter an automobile illegally. Well, I was just trying to see if it worked. It seems to me if you're trying to crack the identified data, that's as culpable as breaking into a bank or breaking into an automobile. And on the First Amendment issue, it's the trying to crack in that would be prohibited. If you get the information, then maybe you can put the information out on the New York Times front page, but it's the trying to crack in that's an unlawful attempt to do something prohibited by statute. Could you comment on that? And maybe I am skewed a little bit. I appreciate your perspective.
Sure. I didn't say that it was impossible to craft a legislative solution. I did say that it would be difficult. And one of the reasons that we think it'd be difficult is because we do see value in having security researchers attempt to crack things like the de-identification standard. So you had spoken about culpability if they attempt to do it. We think that there's value there because it helps prove that the standard is in fact insufficient. And that was one of the reasons why LaTanya Sweeney's study was so famous. It showed us holes in the current standard and prompted us to try to fix them. So we certainly don't want to encourage security researchers to go out and just attack every de-identified health data set that's out there. I think that would be, obviously that would lead to a lot of problems. On the other hand, how do we get the benefit of knowing where the holes are without causing a lot of privacy issues? And that's the challenge. So I don't think it's impossible, I just think it's difficult. Carving out the exception is going to be difficult.
Well, I just want to add one thing onto that, and then to come here, I think there is an awful lot of work that's going on in the field of cryptography right now, and to determine what's more secure, cryptography ciphers that are held private and don't have the ability to be tested, or cryptography ciphers that are held out to researchers to be able to be attacked. And I think most folks are saying for most purposes, especially general commercial purposes, holding cryptography ciphers out in international standards to allow researchers to be able to get at them and to attack them is better and results in more secure technology over time. I think you could create an analogy here to that. Here.
Two points with regard to re-identification attempts by disclosure risk researchers. One, I think a lot of that can be done probabilistically, that it is sufficient to get close to say there's a high probability that this person is re-identifiable without having to go to the length of attaching to them any of the limited data set direct identifiers. And therefore, I think that kind of research probably shouldn't be classified as a re-identification if you're not attaching any of the direct identifiers. The other thing is that everyone's probably aware of the proposed changes to the common rule. And I think one thing that makes a great deal of sense is that if a researcher wants to undertake identification with verification at the level that we have attached this person's name, address, etc., that should fall under the IRB process that's already in place, because it is it's research on identifiable human subjects.
Excellent point. Comments from the panel? I think you hear a lot of nods about the IRB being potentially playing a really good role there.
I just want to make a point about the First Amendment. This isn't a complete response, but I want to point out that there are at least two parties to a transaction, if you will. There's somebody who has the data, and there's somebody who gets the data. I mean, they're also the subject of the data, but that's not the focus now. And so that in order to have a method for control or imposing limits on people, you can provide incentives to the people who disclose data with respect to liability, and give them an incentive to impose restrictions on the people who get the data. And so it's not just the focus on the researchers, if you will, but you can work both sides of the street here and get yourself in the direction of imposing controls that don't conflict with the First Amendment.
Comments?
I agree with that, but by the way, I have to give Bob credit for I mean, you've written about the idea of closing this hole well before we have, so wanted to credit you with that. Although I do still find it very odd that we are very worried about controlling the data handler for activity that a data user might do downstream that is nowhere near foreseeable at this point. I guess, I think of this kind of like in torts terms. There's somebody who might do something very bad. It might be, for the half of you that are lawyers, it might be a superseding act. Or rather, the question is it a superseding act? Well, if it's foreseeable, then no, because that's the sort of risk that we want the controller of the data to predict and to control for. But if we have no reason to think that this is happening, and we have some reason to think that it would be hard for a data user to do this, then I don't think it is valuable to keep the stick on the data producer.
And would the argument then extend to say that there should be practical mechanisms to meet your duty then, if any duty exists downstream, by, for instance, creating contract clauses that then have to be passed on to other recipients of the data and to make them to commit to how they are going to use the data or not to use the data?
Yeah. I think the commitment to not re-identify should flow with the data, or even I don't mind forcing researchers to go to the original source to get the data, just so we have some sort of sense of how many people are accessing it. But
And what happens when it's not hard? I mean, now there's software. If you want to do a brute force attack, you can buy password cracking software, and things change with technology. And what's hard today could be very, very easy tomorrow. So some of these attacks right now are tricky, going to take a lot of effort, but it could very well be easy. You can buy now, maybe someone will sell de-identification software down the road. Now, obviously, we can't plan every possible risk, but when we're doing this, and if you're going to release a lot of data out there, have some at least forward-looking view of kind of where the risks could be, how foreseeable those risks are. I agree that you don't want to respond to unforeseeable, totally, crazy risks and think of, technology hundreds of years from now. But I do think we have to have a broad view of what is potentially out there and what those risks are. Even if they're right now not a super duper high risk, I still think we need to take into account risks and some vision of how technology might evolve.
Final comment. Well, two comments. Rob first, and then Harley.
What I'd like to propose is
A little closer to the mic.
what I'd like to propose is we could learn a lot from security management. Why not looking at privacy as a process? And if you look at risk management, you have the whole process of risk identification and then coming up with countermeasures to mitigate the risk. But you also have to plan and monitor and control. It's like a plan, do, check, act circle. You could apply the same principles of risk management, which is common in the security world, to the privacy problem. And in that way, you would not have to foresee all the possibilities in the future, but by having this iterative approach, if things will become big, then they will show up in a certain point in time, and then you can deal with it.
So I had just wanted to echo what Professor Solov had said about looking into the future and the growing risk of re-identification. We think that risk, as I said, will grow much more with electronic health records. And the issue is not so much that the risk of re-identification is so low. That is admittedly very true, but we want to just take it off the table to an extent for the future. And part of the reason is so that researchers will be more comfortable using it. Regulators will not be poised to perhaps have reactionary legislation. And we, as patients, will be more comfortable with our data being out there.
Great. Thank you very much, and thanks to the panel.
Thank you, David, and thanks to the panel. Jessica, where are you? Jessica, what is CISPRI, the Center for?
It's the Cybersecurity Policy and Research Institute. My name is Jessica Pulsifer, and our director is Lance Hoffman, standing over there in the corner. And we're here. We're really glad that we could partner with the Future Privacy Forum to co-host this event. Basically, we promote and research multidisciplinary solutions for cybersecurity issues such as de-identification and anonymization. We have CISPRI-affiliated researchers with every school within George Washington University. So we have a really, great opportunity to promote this type of cross-disciplinary dialogue. We have hosted a workshop on the economics of cybersecurity. We've hosted workshops on how to develop and promote retention of the cybersecurity workforce. Along the same lines, we administer 2 federally funded scholarship programs for cybersecurity students. So we've had over 50 cybersecurity experts graduate and go on to work for the federal government. And finally, we do a monthly seminar series, which will resume in January. If you'd like to look in your folder, I believe there's some materials on CISPRI, and we'd love for you to join us. So again, we're proud to be an academic sponsor, and if you have any questions, please feel free to see me or to see Lance.
Thank you, and thanks to our friends at IMS Health who helped put on today's lunch. And please thank for me some of our Future Privacy Forum staff, Heidi and Leah and Kanisa, who support all of our work, and Carolyn and Emily. So thanks to all of you. We are hosting drinks on us at the Truman Lounge, which is over, Heidi, over up the stairs and to the right, and you can only get in there if you're invited by a member of the press club. So we have a press club member who has invited us all. So thank you. There's a lot more work to do, and let's talk about some of the things that need to happen. So thank you for joining us today.